Dad loses 42% of income. Still no urgency, warning, and motion to vary support. The ongoing COVID-19 pandemic continues to impact all Canadian families in many ways. It also continues to stifle the workings of the family law courts, which have seen suspension of operations for all but urgent matters in order to optimize the use of precious judicial resources. The court is just starting to reopen now. According to the notice issued to the legal profession for these purposes, urgent issues include those that relate to the safety and well-being of a child, as well as dire issues regarding the party's financial circumstances. Keeping these thresholds in mind, the presiding judge of the court who must determine whether any matter that comes before him or her is sufficiently urgent to be heard. In a recent ruling in a case, the court heard the father's ostensibly urgent motion for a temporary order reducing his child support and terminating his spousal support obligations outright. He had been paying in accord one with numerous previously issued court orders in his years-long legal dispute with the mother. He was asking for the court for urgent relief because his employer had reduced his income by 42% and because of the COVID-19 pandemic. He claimed his situation was accordingly dire under the governing test, and that he had suffered the requisite material change in circumstances, which is required under the family legislation before a court order or a change to the existing support order will occur. The court initially entertained the father's request on the basis that it was presumptively urgent, but declined to make a substantive temporary ruling on the support issue. The father had not made out his case as to the requisite level of urgency, and there was nothing truly dire about his circumstance. After noting that the father had managed to pay child support and spousal support without racking up arrears, and noting that the father was seeking a temporary order, which are not encouraged and should become the focus of the party's litigation, the court found no extenuating circumstance that warranted the father's motion. The court dismissed the father's motion and ordered him to pay the mother's costs. Thank you for watching. If you like this video, give it a thumbs up, or you can subscribe by tapping the bell at the end of the video. You can leave your questions or comments in the comment box below, and we'll endeavor to answer those questions at the end of each week. Until next time, I'm Russell Alexander.